Hi everyone. So today we are going to be talking about employment discrimination. It's a very broad topic here. Specifically, I'm going to be focusing on Title VII of the Civil Rights Act of 1964. And my name is Courtney Shook, and so let's go ahead and get started here. So first, let's start with just a brief history. Title VII is considered to be the most important equal opportunity law ever enacted, as I'm sure you would agree. The 1960s civil rights movement sparked heavy debate about what legal protections employees would have against discrimination in the workplace. And so for the past century, the history of workplace discrimination protections have developed by adding new clauses and understandings, and we'll go over a few of them here today. So, Title VII of the Civil Rights Act of 1964, it specifically prohibits discrimination against employees, applicants, union members on the basis of race, color, national origin, religion, or gender at any stage of employment. So these are considered to be protected classes. So kind of expanding on that a little bit, a class of persons defined by one or more of these criteria, race, color, religion, national origin, gender, age, or disability, is one of those protected classes here. So reading forward a little bit here, it employs to employers with 15 or more employees and labor unions with 15 or more members. It applies to a whole bunch of different kind of organizations like labor unions, depending on where they operate, and then a majority of federal government employment offices as well. Okay, so Title VII of the Civil Rights Act created the Equal Employment Opportunity Commission to monitor Title VII compliance. So they're the ones who are actually going out and policing these things. Just a couple things. Victims must file a claim with the EEOC before bringing a suit to an employer. The EEOC may investigate the claim and attempt to arrange some sort of remedy. If they decide not to investigate, the victim then can bring his or her own lawsuit against the employer in question. And a lot of times, the EEOC does just focus on priority cases, so you won't see them getting involved in every little thing. Just a few other things here with Title VII specifically. Title VII it's a really broad topic, so we're just kind of hitting some major points here today. Won't go over everything, but here are just a couple things to keep in mind. Title VII prohibits both intentional and unintentional discrimination. There is the 4/5 rule, which is a procedure used to determine whether an employer selection procedure is discriminatory. So essentially how that one works is if a selection rate for a protected class is less than 4/5 or 80%, it'll generally be regarded as evidence of disparate impact discrimination or unintentional discrimination. How employers can protect themselves. Every part of Title VII has its own ramifications that employers need to watch out for, and every case has kind of set a standard of what employers need to do to protect themselves. A big thing with like standardized testing and things like that is they need to prove that their qualification standards have a direct relationship to realistic qualifications for the job in question. So that would apply for like degrees needed, high school diplomas, medical exam, everything has to be related to the job. So we'll go into a look at the protected classes here. So first one I'll talk about is discrimination based on religion. So employers cannot show more or less favoritism towards employees based on their religious practices or beliefs, and they cannot require employees to participate in any religious activities. They have to reasonably accommodate for the needs of an employer unless it would cause them undue hardship. So typically, undue hardship means that it would hurt the business if the accommodation were to be made. So if an employee's religion prevented them from working a certain type of job or working on a certain day, the employer has to make reasonable attempt to accommodate these religious requirements unless it would hurt their business. So, gender discrimination. Employees are prohibited from classifying jobs as male or female and from advertising position as male or female unless the employer can prove that the gender of the applicant is essential to the job. There are a couple huge hitters here, and again, we're only going to touch on a few of them, but let's see here. The plaintiff must prove that the gender was a determining factor. This also includes, pregnancy discrimination. The Pregnancy Discrimination Act of 1978 amended Title V to include discrimination based on pregnancy. Wage discrimination. This is huge today. The Equal Pay Act of 1963 requires equal payment for both female and male employees doing similar work at the same organization. If the difference is due to any other factor than gender, such as merit or seniority, then it does not violate the Equal Pay Act. All right, moving forward to age discrimination here. So the Age Discrimination in Employment Act, the ADEA, prohibits employment discrimination on the basis of age against 40 plus years of age or older. And it also prohibits mandatory retirement for non-managerial workers. There is also the protected class of discriminating against people with disabilities. The ADA, or the American Disabilities Act, requires that employers reasonably accommodate the needs of persons with disabilities unless to do so would cause the employer to suffer undue hardship. So again, we're hearing those reasonable accommodations and undue hardship words here. Reasonably accommodate would be like putting in ramps for people with disabilities, making the job application, accessible so people can call and apply for the job, type, they can write a letter if there's any disability that requires that. And undue hardship in this case is typically determined based on the finances of what is required compared to the business finances to determine what is actually reasonable. So with this one, if the business can afford it, they should be making these accommodations. Okay, so just going over some notable Supreme Court cases here. Let's start with McDonnell Douglas Corp versus Green. So just going to kind of briefly go over what the Supreme Court determined here. Not necessarily the specifics of the case, but this is kind of how Title VII has changed over the years. So in McDonnell Douglas Corp versus Green, the Supreme Court holds that a charging party can prove unlawful discrimination indirectly by showing, for example, in a hiring case, that 1, the charging party is a member of Title VII protected group, 2, he or she applied and was qualified for the position sought, 3, the job was not offered to him or her, and 4, the employer continued to seek applicants with similar qualifications. If the plaintiff can prove these 4 elements, the employer must show a legitimate, lawful reason why the individual was not hired. The employee still may prevail if he or she discredits the employer's asserted reason for not hiring him or her. And then in Albemarle Paper Company versus Moody, the Supreme Court decides that after a court has found an employer guilty of discrimination, the wronged employee is presumed to be entitled to back pay. And then in Transworld Airlines Inc. versus Hardison, the Supreme Court decided its first Title VII religious discrimination case. The court stated that under Title VII, employers must reasonably accommodate an employee's religious needs unless to do so would create an undue hardship for the employer. the court defines hardship as anything more than the minimum costs. So those are just a few things that helped kind of shape where we stand with Title VII today. Again, everything is based on precedent, so these are just kind of some big heavy hitters to where the Supreme Court decided on something, and now here's it stands, and everything gets added into Title VII as it is. Okay, so this kind of concludes my presentation here. Again, Title VII is considered to be the most important equal opportunity law ever enacted because it contains the broadest coverage, prohibition, and remedies to individuals. This is so important, especially in today's world where we are very focused on equality. This is a goal, this is very important and necessary, and we need to make sure going into the business world here, us as college students, that we are following these laws so that we can have equality within the workforce and that we're not discriminating either intentionally or unintentionally against anyone. All right. Thank you guys.